Without objection.
Mr. President, I'm glad to join Senator Stabenow, who is on the floor just now, to respond to the shameful lies and gross exaggerations that have been claimed by some on the other side of the aisle. Earlier this week, we voted on legislation that some of my colleagues claimed was needed to outlaw infanticide, the killing of babies. How absurd. It is and has always been illegal to kill any human, including infants. So what was in that legislation that we voted on earlier this week? To honestly discuss the bill, we need to have a factually and medically accurate conversation about abortion. A healthy fetus becomes potentially able to live outside the womb at about 24 weeks of pregnancy. Very few abortions occur after that. Less than 1%, and generally are performed either because the fetus has a fatal condition or the pregnant woman's life or health is at severe risk. These are heartbreaking situations involving very wanted pregnancies. Hardly the time for the heavy hand of government to reach into our wombs. Under this bill, doctors will be required to resuscitate infants born with fatal conditions, even if the parents did not want these measures that could prolong their infant's suffering and instead wanted to spend the limited time they had with their baby comforting their child and holding them close. How dare anyone pretend to know what care is best for these families instead of trusting them and their doctors to decide? How dare Congress interject itself into a decision that we have no business deciding for others? And yet, this is exactly what this bill would have done. I encourage my colleagues to read stories from women who have been speaking out about their experiences with abortion later in pregnancy. These stories are easily found on the internet as well as in the national press as more women feel under attack and are coming forward to tell their stories. Perhaps in hearing from these women, my colleagues will realize what these women need is compassion, not condemnation. Stories like that of Dana Weinstein, who bravely told her story to CNN. Years ago, Dana and her husband learned at 31 weeks that their daughter's brain had a severe defect. Doctors told the couple that their daughter would not be able to suck or swallow and would most likely suffer from uncontrollable seizures upon birth. They heard what a resuscitation order would entail. They listened to what an existence, short-lived or otherwise, would look like. They were briefed on hospice care. After the diagnosis, the kicks in Dana's belly, which had given her so much joy, became unbearable. She feared that her daughter was seizing and maybe suffering. Ultimately, Dana and her husband decided to get an abortion. For this baby they loved, it felt like, in their words, the more peaceful path for her passing. These are the stories. Compassion and understanding of what's needed in these instances. But instead of compassion, what my colleagues have offered this week is inflammatory political rhetoric, shaming and intimidating women and their providers that care for them in an attempt to score partisan points. President Trump, never missing an opportunity to score partisan points, weighed in on Twitter, claiming Senate Democrats, quote, don't mind executing babies after birth, end quote. And today, former Governor Scott Walker said to a crowd at the Conservative Political Action Conference that, quote, people are taking already born babies from the hospital and aborting them there, end quote. A comment that doesn't even make sense. Republican National Committee Chair Ronna McDaniel chimed in at the same conference, calling the choice that women like Dana make murder. These charges are false, incendiary, and this sort of language is intended to incite the Republican Party's base. It emboldens violence against abortion providers, violence which nearly doubled from 33 reported death threats or threats of harm in 2016 to 62 in 2017, according to the National Abortion Federation. The hard truth is that the Republican Party hurts women. And one of the ways they are doing this is by working as hard as they can to set up barriers to or eliminate entirely safe, legal abortions wherever they can. They demonize women who face the heartbreaking situation of needing an abortion later in pregnancy, oftentimes for medical reasons. They want to cut off crucial healthcare dollars to providers who even discuss abortion with patients. This is a gag rule that this administration is seeking to impose. They create loopholes to allow businesses to exclude coverage for contraception for workers. And to make sure that these and all of their other efforts stick, they pack the federal courts with a line of aggressively anti-choice judges to uphold federal agency actions and state laws restricting abortion access. Doing the bidding of his right-wing ideologue supporters like the Federalist Society and the Heritage Foundation, Donald Trump has sent judicial nominee after nominee with records of attacking a woman's right to choose as laid out in the Supreme Court's opinion in Roe v. Wade and restated in Planned Parenthood v. Casey. These nominees come before the Senate Judiciary Committee on which I serve and parrot the line provided for them by the Trump administration. When asked if they will respect precedent and uphold Roe v. Wade, they say they will follow the law. Then, when they get confirmed, they are in a position with their lifetime appointments to do exactly the opposite. The prime and most dangerous example of this kind of bait and switch is Brett Kavanaugh, a notoriously right-wing political lawyer appointed by George W. Bush to the second highest court in the United States, the Court of Appeals for the D.C. Circuit. Kavanaugh was not even on Donald Trump's original so-called short list of possible Supreme Court nominees. Not the list released before the 2016 election and not the first list released thereafter. No, Kavanaugh only found a place on that list after he wrote a harsh dissent in a case involving a young refugee's right to an abortion. A minor, then 17 years old, was being kept in custody of the Department of Health and Human Services because she had entered the United States without documentation. In Texas, where she was held, in order to access abortion services, a minor must have parental consent or receive permission from a judge. This is called a judicial bypass, to proceed without that parental consent. In this case, called Garza v. Hargan, the young woman did go through the process of going to court and receiving a judicial bypass. And she had people willing and able to transport her and to pay for the health services that she needed. But the radical Trump appointee in charge, well known for his anti-abortion views, decided that it would be in her best interest to find adult sponsors for her first, presumably to help her make a decision. But the Texas court had already decided that she could make her own decision, and she did. She challenged the Trump appointee and his agency, and ultimately, a majority of the D.C. Circuit agreed with her. She had the legal right to an abortion, and the federal government could not delay any further. But Brett Kavanaugh, sitting on that D.C. Circuit, disagreed and wrote a dissent which must have captured the attention of those in charge of Donald Trump's Supreme Court shortlist, because not long after, his name appeared on that list. And what did he write to earn his place on the list and eventually a nomination to the United States Supreme Court? He wrote a dissenting opinion that falsely characterized the case, the Garza case, as one about parental consent, which we know was not so because a judicial bypass was already in place. And he wrote the dissent using the code words of the extreme anti-choice, anti-woman wing of the Republican Party. He accused the majority of that court of creating, quote, a new right for unlawful immigrant minors in U.S. government detention to obtain immediate abortion on demand, end quote. He was wrong. There was no new right being created. He falsely claimed that he claimed that by permitting the abortion, quote, the majority's decision represents a radical extension of the Supreme Court's abortion jurisprudence, end quote. Wrong again. The majority decision was correct under Roe v. Wade. He wrote that it was not an undue burden for this young woman to be prevented from getting an abortion until a sponsor family could be found for her. This was not even a legal argument, but he based his dissent on it. That's the dissent that moved Brett Kavanaugh to the head of the line on the short list for a nomination to the United States Supreme Court, where he sits. So when he came to the Judiciary Committee for a hearing, some senators, myself included, were rightly skeptical that he would respect precedent if confirmed. At his hearing, Ranking Member Dianne Feinstein asked Judge Kavanaugh about Roe v. Wade and its status as settled precedent. He testified that Roe was, quote, settled as a precedent of the Supreme Court, entitled to respect under principles of stare decisis. Further went on, Planned Parenthood v. Casey reaffirmed Roe and did so by considering the stare decisis factors. So Casey now becomes a precedent on precedent, end quote. Sure sounds like someone who will apply the precedents of Roe and Casey and others that rely on them, doesn't it? Not so. The very first opportunity he got, Brett Kavanaugh, as Supreme Court Justice, voted against following precedent. Not 4 months after his confirmation, Justice Kavanaugh voted in the minority in a Supreme Court case called June Medical Services v. G to allow a restrictive anti-abortion law in Louisiana to take effect. This law would have so restricted access to abortion that only one provider would have been left in the entire state of Louisiana of 4.7 million people. Even Chief Justice Roberts voted with the majority to block the law. That is because it was clear from recent precedent in Whole Women's Health versus Hellerstadt that such restrictions don't meet constitutional standards. Justice Kavanaugh's cavalier attitude to the burden that he would put on a woman's ability to exercise her constitutional right is no surprise. His callous disregard for the way unwanted pregnancies can change the lives of women and children is not unexpected. And his willingness to hew the party line of his supporters and ignore the assurances he gave the Senate is simply par for the course with Trump judicial nominees. This is what they do. It is an abuse of power, and women across the country are paying for it. Mr. President, why do my colleagues across the aisle use this chamber time and again to bring forward political shams that shame and re-traumatize women who face profoundly heartbreaking situations? The will of over half of this country, 67% of Americans support Roe v. Wade and access to safe, legal abortion. 67% of Americans support a woman's right to choose. How is it that Republicans continue to bring forward bill after bill, amendment after amendment that goes against a constitutionally protected right of women? Of women. This is why I say Republicans hurt women. I am proud of the vote that I cast in opposition to the sham bill we voted on this week. My vote was rooted in fact and understanding about what an abortion later in pregnancy actually means. It was rooted in the understanding that when faced with these difficult situations, These decisions are best left to a woman and her doctor. These decisions should not rest with the United States Senate. My vote was cast with a clear understanding that if unchecked or unchallenged, this administration and this Senate will continue to assault a woman's right to choose and chip away at it bit by bit, where it will end up being a nullity. And that's what they want. I will continue to stand in opposition to attacks that seek to limit the personal freedom of women across the country. And what could be more of a personal freedom for a woman than to exercise control over her own body? I yield the floor.